raised in petition number E2 of 2021 is whether there is a legal or regulatory framework to regulate the verification and other processes required under Article 257(4) and 5 of the Constitution. A related question is whether, if such a legal or regulatory framework is required, one in fact exists. Finally, the petition raises the issue whether the IEBC has the required infrastructure for purposes of conducting the verification mandate imposed on it by Article 257(4) of the Constitution. The respondents have urged the court to find that the issues in this petition, these three issues, as framed above, were settled in two earlier cases, that is, the Titus Adila case, which we've cited before, and the ex parte Kenda Muriuki case, which you've also cited before. In the interest of everybody having their dinner on time, I will not go over our reasoning on those two decisions, except to say that we concluded that those two decisions have not covered the three issues as framed in this petition. The petitioner argues that the IEBC cannot constitutionally conduct verification under Article 257(4) of the Constitution in the absence of a regulatory framework. The petitioner further argues that no such regulatory framework exists. The petitioner points out that whereas Parliament has attempted to pass legislation on Article 257 of the Constitution, it has not been enacted yet. There are two related bills still pending in Parliament. Hence, the petitioner argues that even Parliament is aware that there is a lacuna. The petitioner further argues that the IEBC is also aware of the lacuna and has attempted to address it through its administrative procedures for the verification of signatures in support of constitutional amendment referendum, which I will call hereafter administrative procedures, first approved on the 15th April 2019 and revised in 2020. However, the petitioner contests the legality of the administrative procedures on two counts. First, the petitioner argues that the administrative procedures were developed without public participation. Second, the petitioner argues that the administrative procedures are statutory instruments which could not become effective before parliamentary approval. Consequently, the petitioner argues that IEBC has no legal or regulatory framework to use in the verification of signatures for purposes of referendum under Article 257(4) of the Constitution. The petitioner requests for certain reliefs flowing from these arguments, including a declaration that the existing administrative procedures are invalid and could therefore not be used to verify signatures in support of the Constitution Amendment Bill. On the other hand, the IEBC's position is that a textual reading of Article 257(4) of the Constitution yields the conclusion that the IEBC is only required to verify that a popular initiative to amend the Constitution is supported by 1 million registered voters and not the signatures. Counsel for IEBC indeed submitted that it was not the mandate of the IEBC to verify whether or not the signatures were forgeries or obtained without consent. Its only role, insisted counsel for IEBC, is to confirm that the popular initiative bill is supported by 1 million voters. Consequently, the IEBC maintained that it requires no more. If the IEBC's role is the venial administrative task of ascertaining numbers, then perchance no further legal or regulatory framework would be required. In order to answer this question, we turn to the affidavit of Dennis Wawero, which was sworn on 5th February 2021. The affidavit is sworn on behalf of the BBI National Secretariat, one of the respondents in this petition. Mr. Wawero has annexed a document entitled "The Findings of the Commission on the Process of the Verification of Signatures for the Proposed Amendment to the Constitution of Kenya 2010 through a Popular Initiative or Core Kenya Initiative," dated 22nd March 2016. Hereinafter, I will simply call this report the IEBC Verification Report. This was the report of the then chairperson of the IEBC on the verification process carried out by the IEBC with respect to the Constitutional Amendment Initiative known as Okoa Kenya Initiative in 2016. The IEBC Verification Report explicitly acknowledged IEBC's role under Article 257.1 and 257.4 of the Constitution, stating at paragraph 8 of the document that the operative phrase as far as the mandate of the IEBC and Article 257.4 is concerned is to verify that the initiative is supported by at least 1 million signatures of registered voters. The questions the Commission posed were, what is to verify? How do you verify that a person is a registered voter? How do you go about the entire verification process? This is a direct quote from the IEBC report. Applying the definition of verify from the Black's Law Dictionary, this same report by the IEBC states as follows, and I quote it: "It appears, therefore, to verify is not to casually look at information presented to you, but to take steps that will allow one to affirm, even under oath, the correctness, accuracy, truthfulness, or exactness of the information." On whether the Commission was to verify the authenticity of the signatures only, or what the supporters, or that the supporters are registered voters, that same report by the IEBC stated, the Commission's view is that the verification entails confirming that the initiative is supported by registered voters as evidenced by their signatures. After reviewing practices in other jurisdictions, it was clear to the IEBC that a person mandated to verify signatures must satisfy herself or himself that the said signatures belong to the persons whose names appear against them. Therefore, in 2016, with respect to the Okoa Kenya initiative, the popular initiative to amend the first popular initiative to amend the Constitution of Kenya 2010, the IEBC determined that to accomplish its mandate, it was required to carry out the verification of signatures and the verification that the supporters of the initiatives were registered voters. It determined that the proper sequence to achieve this was, in their own words, first, to confirm that the people supporting the initiative were registered voters, and second, to move to the second step of ascertaining the authenticity of the supporters' signatures. At paragraph 13 of the IEBC verification report, it states, in the case of Article 257.4 of the Constitution of Kenya, it would follow that the Commission has to verify that at least 1 million registered voters supported the initiative. Once the Commission is satisfied that 1 million registered voters support the initiative, it would then proceed to the next step of verifying that the signatures appended thereto are valid signatures of the registered voters. This is the process that the Commission followed in the Okoa Kenya initiative. Again, those are the words of the IEBC itself. In the case of Okoa Kenya initiative, as reported in the IEBC verification report, once the IEBC received the draft bill and the booklets of signatures, it embarked on the first step of verifying that the signatories were registered voters. However, when the number of registered voters fell below the 1 million mark after the first stage of the verification process, the IEBC, in its own words, did not consider it prudent to go to the next step of verifying the authenticity of the signatures of the registered voters, either by sampling method or otherwise. End of quote. Given this analysis of how IEBC handled the Okoa Kenya initiative, given in a sure-footed clarity by IEBC itself, and in its own words, etched in its own report, there is no doubt that the IEBC understands that its mandate and role and Article 257.4 of the Constitution includes a two-step process of, first, ascertaining the numbers of registered voters in support of a popular initiative to amend the Constitution, and second, verifying the authenticity of the signatures of the registered voters claimed to be in support of the popular initiative. It is, therefore, plainly startling that in the present petition, the IEBC has taken the clearly disingenuous position that its role is limited to merely ascertaining the numbers of registered voters in support of the popular initiative. This position is belied by its own report analyzed above. It is also belied by the text and spirit of the Constitution. As the IEBC verification report plainly acknowledged, the only reasonable meaning of the term verify, as used in Article 257.4 of the Constitution, includes both the ascertainment of the numbers and confirming the authenticity of the signatures submitted. If the importance of the above two-step process of verification of signatures and Article 257(4) of the Constitution is not sufficiently clear yet, a comparative analysis of voter verification for purposes of general elections will clarify it further. We've done that whole comparative analysis in the next part of our judgment, which I will not reproduce here, but I will reproduce the conclusion to that comparative analysis. The provisions of the Elections Act respecting voter verification demonstrate that IEBC determined that it was necessary to carry out a verification process for voter registration in the case of elections. The rules provide the time frames within which the voter verification is to be done and the actual process to be followed. They require, among other things, a voter who seeks verification to appear personally before a registration officer to verify the information held in the register. This comparative analysis demonstrates what the law requires IEBC to do in the case of voter verification for purposes of elections. There is no doubt that the IEBC takes its role in voter registration as more than a ceremonial exercise. The IEBC has established substantive standards and procedures to ensure the integrity of voter registration and verification regarding elections. If the IEBC is so scrupulous in carrying out its role in voter verification for elections purposes, it follows that the same standard at the very least should apply in the case of verification of signatures for purposes of constitutional amendments through popular initiative and Article 257(4). The above analysis establishes that the IEBC's role under Article 257(4) involved both the ascertainment of numbers of registered voters in support of a popular initiative to amend the Constitution, as well as verification of the authenticity of those signatures. The question that arises then is whether the IEBC has any legal or regulatory framework to achieve its mandate under Article 257(4). If the IEBC has a regulatory framework, namely the Elections Registration of Voters Regulations 2012 for voter verification for purposes of elections, it follows that the IEBC needs a regulatory framework for signature verification under Article 257(4) of the Constitution. Does the IEBC have such a regulatory framework for signature verification for purposes of Article 257(4)? The IEBC argues that the existing statutory framework is sufficient regulatory framework, and further that if it is not sufficient, the administrative procedures adequately cover the signature verification process. As analyzed above, the existing statutory framework is not sufficient for verification of signatures under Article 257(4) of the Constitution. Indeed, it is instructive that the Constitution Amendment Initiative that came after the Okoa Kenya Initiative, namely the Punguza Mzigo Initiative, the IEBC noted that there were, and I quote, no statutory procedures or timelines for the verification of supporters of constitutional amendment drives through popular initiative, end of quote. To fill in the gap, the IEBC developed administrative procedures approved on the 15th of April 2019. The question that arises then is whether the administrative procedures are lawful, and if so, whether they adequately serve the role of providing the required regulatory framework. The petitioner has urged us to declare the administrative procedures invalid for lack of public participation. The IEBC did not contest the fact that the administrative procedures were developed without public participation as required under Article 10 of the Constitution. For that reason alone, we would have no difficulty in adjudging the administrative procedures invalid. The petitioner also argued that the administrative procedures are invalid because they are statutory instruments and they have not been subjected to parliamentary approval as required under Sections 10 and 11 of the Statutory Instrument Act. Other than weakly argue that the administrative procedures are not statutory instruments, the IEBC has not seriously contested this argument. It requires no belabored analysis to conclude that the administrative procedures are statutory instruments, as that term is defined in Section 2 of the Statutory Instruments Act. Moreover, the administrative procedures were not gazetted as required by Section 22 of the same Act. Consequently, the administrative procedures are invalid both because of lack of public participation as well as the failure to comply with the provisions of the Statutory Instruments Act. Even if the administrative procedures survive this Public Participation and Statutory Instruments Act scrutiny, we would still find them invalid for purposes of providing the regulatory framework required under Article 257(4) for two other reasons. First, the administrative procedures were developed and revised without the requisite quorum under Section 8 as read together with the second schedule to the IBC Act, as we have said above in this judgment. Second, a perusal of the administrative procedures reveals the obvious point that they do not have provisions or procedures for the authentication of signatures, which we have found is a necessary step in the verification exercise required under Article 257(4) of the Constitution. In addition, even if the administrative procedures had been valid, there is clear evidence that the IEBC did not comply with them. For instance, the IEBC published the list on its website on Thursday, 21st January 2021. Members of the public had up to Monday, 25th January 2021 to read the list and raise any issues they had with the list. It is noteworthy that the time period given for information and verification fell short of the time the IEBC's administrative in the IEBC's administrative procedures. The administrative procedures provided for a 2-week period, while the IEBC gave only 5 days, both days inclusive and including the weekend. In view of the foregoing analysis, we conclude the following. First, a legal or regulatory framework for the verification of signatures under Article 257(4) of the Constitution was required. Second, the legal or regulatory framework required does not exist, and the convergence of existing statutes does not adequately form the requisite regulatory framework required under Article 257(4) of the Constitution. Third, the administrative procedures developed by the IEBC are invalid for the following reasons. One, they were developed without public participation as required under Article 10 of the Constitution. Two, they are in violation of the Statutory Instruments Act for want of parliamentary approval and for want of publication as discussed. And three, they were developed without quorum. Fourth, even if the administrative procedures had been valid, in the present case, the IEBC violated them. Next, we'll briefly consider the requirement for nationwide voter registration before any proposed referendum. The petitioner in petition number E416 of 2020 argued that every person has a right to make political choices and voter registration should supersede constitutional amendment process through a referendum. In his view, the IEBC cannot conduct a referendum before conducting nationwide voter registration. The IEBC contended that no one will be disenfranchised if the proposed referendum was held. According to the IEBC, voter registration did not stop in 2017. The IEBC maintained that in fulfillment of its obligations under the Constitution and the law, it undertakes continuous voter registration and updating of registered voters, which ended just before the Kibra by-elections in 2018 with 108,000 more registered voters. Article 38 of the Constitution guarantees every citizen political rights, including the right to free, fair, and regular elections based on universal suffrage and the free expression of the will of the elector. Every adult citizen has the right to be registered as a voter without unreasonable restriction and to vote in an election or referendum. Article 88 establishes the IEBC, while sub-article 4 of that article confers on it the mandate to conduct referenda and elections, conduct continuous voter registration, and regular revision of the voters' roll. This role is also found in the IEBC Act. Section 4 of that Act requires continuous registration of voters and revision of voters' roll. Similarly, Section 5 of the Election Act requires the IEBC to carry out voter registration and revision of the register of voters at all times except for a stipulated time just before the elections. These requirements are aimed at enabling citizens not only exercise but also realize the political rights guaranteed under the Constitution. The IEBC is under both a constitutional and statutory obligation to register voters and revise voters' registers at all times. The IEBC did not demonstrate to this court in answer to the petitioner's claims that it had conducted continuous voter registration, and if so, when voter registration was last conducted. It only stated, without any evidence, that it conducts continuous voter registration at constituency headquarters. We begin by noting that every single day, citizens attain the voting age. These new citizens have a right to be registered as voters and to participate in any proposed referendum. There was no evidence placed before this court that the IEBC has been discharging its constitutional and statutory obligations to enable citizens who have recently attained the voting age to register as voters. The IEBC also stated that the last time the voter register was revised was just before the Kibra by-election. This was a confirmation that it was not discharging its constitutional and statutory mandate to continuously register voters and review the register of voters. There was also no evidence that the IEBC had sensitized citizens that there was continuous voter registration. Holding a referendum without voter registration, updating the voters register, and carrying out voter education would particularly disenfranchise citizens who had attained voting age but had not been given an opportunity to register as voters, thus violating their constitutional right to vote and make political choices. To register and vote is a right under the Bill of Rights. Article 20 of the Constitution is clear that the Bill of Rights applies to all law and binds all state organs and all persons, and every person is to enjoy these rights to the greatest extent consistent with the nature of the right or fundamental freedom. In this premise, Article 21 of the Constitution states that it is a fundamental duty of the state and every state organ, including the IEBC, to observe, respect, protect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. We are persuaded, and we agree with the petitioner, that holding a referendum without first conducting voter registration would violate the very essence of the rights of a class of citizens who have not been given the opportunity to register and vote in deciding their destiny. Next, I will turn to the question that addresses whether conducting the referendum in the current prevailing circumstances of COVID-19 pandemic violates Article 43 rights of the Constitution. The petitioner in petition E416 of 2020 argued that continuing the constitutional amendment process, and in particular holding the referendum, will violate Article 43(1)(a) of the Constitution. It is this petitioner's arguments that the country, and indeed the world, is going through an unprecedented COVID-19 pandemic, which requires resources to combat. He argued that continuing with the constitutional amendment process will not only lead to the spread of the disease, but will also use much-needed resources for the referendum, thus deny the people realization of their right to the highest attainable standard of health guaranteed under Article 43(1)(a) of the Constitution. Honorable Raila Odinga, the Honorable Attorney General, the BBI Steering Committee, the National Assembly, the Senate, and IEBC were all united in denying this petitioner's claim. They maintained that the petitioner did not specifically plead and adduce evidence to support his arguments, and therefore the prayer should be denied. Article 43 of the Constitution guarantees every person the right to the highest attainable standard of health, which includes the right to health care services and reproductive health. At sub-article 3, it obligates the state to provide appropriate social security to persons who are unable to support themselves and their dependents. The right to health is not the same as the right to be healthy. The right to health means the right to enjoy a variety of goods, services, and conditions that are necessary to one's well-being. It is usually based on government's programs and goals that are realized for a long-term basis, usually dependent on availability of resources. From the constitutional standpoint, a country's difficult financial situation will not absolve it from taking key steps towards realization of this right for its citizens. The argument put forward by the petitioner, as we understand it, is that conducting a referendum now will provide an environment for the spread of the coronavirus, and therefore this court should stop the government from conducting such a referendum until the pandemic is over. He also argues that the resources that are to be used for the referendum should be channeled towards fighting the pandemic. We have anxiously considered the argument by the petitioner and those by the respondents. The issue raised by the petitioner, though novel, was not properly supported by sufficient evidence. Without such evidence to support the alleged threatened violations of the right to health, we are unable to make the findings the petitioner craves. We find it necessary to remind the petitioner and other public-spirited litigants who are keen to enforce socio-economic rights enshrined in Article 43 of the Constitution what this court, differently constituted, stated in William Ramogi and 3 others versus the Attorney General. We must emphasize, I'm quoting that court, the importance of adherence to the rules of evidence, both in terms of presentation, authenticity and foundation, and quality of evidence, that is, credibility and probative value required to establish violations of fundamental rights and freedoms, especially in public interest or strategic litigation. The rules of evidence apply with equal force to this species of litigation as they do in run-of-the-mill litigation. This is especially true for cases where claimed violations are most appropriately proved by empirical evidence. Such evidence and data are often generated by experts and must be presented in adherence with the rules on presentation of expert evidence. Of course, reliance on empirical data does not detract from the need in appropriate cases to present direct evidence of the lived realities of the affected people on whose behalf the public interest litigation has been filed. We need not say more on this issue. The last issue we were asked to address in these consolidated petitions before we make our conclusions is on the alleged parliamentary infirmity arising from the Chief Justice's advisory for the dissolution of Parliament. The petitioner in E416 made the argument that this court should compel the President to dissolve the National Assembly and Senate following the advice of the Chief Justice dated 21st of September 2020, and further find that the two houses cannot receive and act on the BBI's Constitutional Amendment Bill as they stand to be dissolved as advised by the Chief Justice under Article 261(7) of the Constitution. The issue of whether or not the President should dissolve the National Assembly and the Senate is live in Milimani High Court Petition number 302 of 2020, and the parties are Third Way Alliance for the Speaker of the National Assembly and another, which has been consolidated with Judicial Review Case number 1108 of 2020, as well as petition number E291 of 2020 and E300 of 2020. All those are currently pending before another bench of this court. The prayers the petitioner seeks in prayers H and I in their petition E416 of 2020 are subject in those consolidated petitions. In that regard, the petitioner may apply to join those petitions and urge its release jointly with the petitioners in those petitions. We decline the invitation to deal with these issues in these consolidated petitions. And now, our council, ladies and gentlemen, Kenyans who are listening, this is the time to sit up. We are going to read our conclusions and findings. For those of you who are interested in getting what they call the plain English version of, or the summary of the decision, when you finally receive this long judgment later tonight, you can please go straight to paragraph 743, which I will now read, because it summarizes all our findings. And thereafter, I will read the orders that we have made. Having considered all the issues before us in these consolidated petitions, we have made inter alia the following conclusions. 1. The text, structure, history, and context of the Constitution of Kenya 2010, all read and interpreted using the canon of interpretive principles decreed by our Constitution, yield the conclusion that the basic structure doctrine is applicable in Kenya. 2. As applied in Kenya, the basic structure doctrine protects certain fundamental aspects of the Kenyan Constitution from amendment through the use of either secondary constituent power or constituted power. 3. The essential features of the Constitution forming the basic structure can only be altered or modified by the people using their sovereign primary constituent power and not merely through a referendum. 4. From a holistic reading of the Constitution, its history, and the context of the making of the Constitution, the basic structure of the Constitution consists of the foundational structure of the Constitution as provided in the preamble, the 18 chapters, and the 6 schedules of the Constitution. It also includes the specific substantive areas Kenyans thought were important enough to pronounce themselves through constitutional entrenchment, including the provisions on land and environment, leadership and integrity, public finance, and national security. 5. The basic structure doctrine protects the core edifice, foundational structure and values of the Constitution, but leaves open certain provisions of the Constitution as amendable through the procedures outlined in Articles 255, 256, and 257 of the Constitution, in as long as they do not change the basic structure. 6. There are certain provisions in the Constitution which are insulated from any amendment at all because they are deemed to express categorical core values. These provisions are, therefore, unamendable and cannot be changed through the exercise of secondary constituent power or constituted power. 7. The sovereign primary constituent power is only exercisable by the people after 4 sequential processes, namely civic education, public participation and collation of views, constituent assembly debate, and ultimately a referendum. 8. The power to amend the Constitution through the popular initiative route under Article 257 of the Constitution is reserved for the private citizen, for Wanjiko only. Neither the President nor any state organ is permitted under our Constitution to initiate constitutional amendments using the popular initiative route. 9. Under Article 143(3) of the Constitution, the President can be sued in his or her personal capacity during his or her tenure in office, except for actions or omissions in respect of anything done or not done in the exercise of his or her powers under the Constitution. 10. The Constitution Amendment Bill 2020, which was developed by the BBI Steering Committee and is being promoted by the BBI Secretariat, is an initiative of the President. The President does not have constitutional mandate to initiate constitutional amendments through popular initiative under Article 257 of the Constitution. 11. To the extent that the BBI Steering Committee was employed by the President to initiate proposals to amend the Constitution, contrary to Article 257 of the Constitution, the BBI Steering Committee is an unconstitutional entity. 12. Additionally, the BBI Steering Committee is unlawful because the President violated the provisions of Article 132, sub-Article 4A of the Constitution in its establishment. 13. In taking initiatives to amend the Constitution other than through the prescribed means in the Constitution, the President failed to respect, uphold, and safeguard the Constitution, and to that extent, he has fallen short of the leadership and integrity threshold set in Article 73 of the Constitution, and in particular, Article 73, 1A thereof. 14. The history of Article 257 of the Constitution, read together with Articles 95(3) and 109(1) and 2 of the Constitution, yields the conclusion that in order to effectively carry out referendum process as contemplated under our Constitution, it is necessary that a specific legislation be enacted for that purpose. 15. Notwithstanding the absence of an enabling legislation as regards the conduct of referenda, such constitutional process may still be undertaken as long as the constitutional expectations, values, principles, and objects, especially those in Article 10 of the Constitution, are met. 16. Parliament and the county assemblies or any other state organ cannot, under the guise of consideration and approval of a popular initiative to amend the Constitution under Article 257 of the Constitution, alter or amend the Constitution Amendment Bill presented to them. 17. Article 255, sub-Article 1 of the Constitution yields the conclusion that each of the proposed amendment clauses ought to be presented as a separate referendum question. 18. Article 89(1) of the Constitution, which provides for the exact number of constituencies, while being part of the basic structure of the Constitution, is not an eternity clause. It can be amended by reducing or increasing the number of constituencies by duly following and perfecting the amendment procedures outlined in Article 255 to 257 of the Constitution. 19. The criteria and procedure for delimitation and apportionment of constituencies set out in Articles 89.4, 89.5, 89.6, 89.7, 89.10, and 89.12 are unamendable constitutional provisions. In other words, they are eternity clauses, and they can only be amended by the exercise of primary constituent power. 20. It is unconstitutional for a constitution amendment bill to directly allocate and apportion constituencies in contravention of Article 89 of the Constitution. 21. The Independent Electoral and Boundaries Commission cannot conduct any proposed referendum because 1. It has no quorum. The quorum for the conduct of business by the IEBC is 5 commissioners, period. 2. The IEBC has not carried out nationwide voter registration. 3. The IEBC has no legal or regulatory framework for the verification of signatures as required by Articles 257(4) of the Constitution. And lastly, in view of what we just said about the IEBC, all the actions taken by the IEBC with respect to the Constitution Amendment Bill 2020 are null and void. And now, our disposition, the orders that we will give in the consolidated petitions. The orders which recommend themselves, which we hereby grant, are the following. 1. A declaration hereby issues 1. That the basic structure doctrine is applicable in Kenya. 2. That the basic structure doctrine limits the amendment power set out in Articles 255 to 257 of the Constitution. In particular, the basic structure doctrine limits the power to amend the basic structure of the Constitution and eternity clauses. 3. We declare that the basic structure of the Constitution and eternity clauses can only be amended through the primary constituent power, which must include 4 sequential processes, namely civic education, public participation and collection of views, constituent assembly debate, and ultimately a referendum. 2. A declaration is hereby made that civil court proceedings can be instituted against the President or a person performing the functions of the office of the President during their tenure of office in respect of anything done or not done contrary to the Constitution. 3. A declaration is hereby made that the President does not have authority under the Constitution to initiate changes to the Constitution, and that a constitutional amendment can only be initiated by Parliament through a parliamentary initiative and Article 256, or through a popular initiative and Article 257 of the Constitution. 4. A declaration is hereby made that the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report established by the President, V-Day, Kenya Gazette Notice number 264 of 3rd January 2020, and published in a special issue of the Kenya Gazette of 10th January 2020, is an unconstitutional and unlawful entity. 5. A declaration is hereby made that being an unconstitutional and an unlawful entity, the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report has no legal capacity to initiate any action towards promoting constitutional changes under the Article 257 of the Constitution. 6. A declaration is hereby made that the entire BBI process culminating with the launch of the Constitution of Kenya Amendment Bill 2020 was done unconstitutionally and in usurpation of the people's exercise of sovereign power. 7. A declaration is hereby made that Mr. Uhuru Muigai Kenyatta has contravened Chapter 6 of the Constitution, and specifically Article 73, Sub-Article 1, Sub-Sub-Article A, Sub-Sub-Sub-Article 1, by initiating and promoting a constitutional change process contrary to the provisions of the Constitution on amendment of the Constitution. 8. A declaration is hereby made that the entire unconstitutional change process promoted by the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report is unconstitutional, null and void. 9. A declaration is hereby made that the Constitution Amendment Bill 2020 cannot be subjected to a referendum before the IEBC carries out nationwide registration exercise. 10. A declaration is hereby made that the IEBC does not have quorum stipulated by Section 8 of the IEBC Act as read with paragraph 5 of the second schedule to the Act for purposes of carrying out its business relating to the conduct of the proposed referendum, including the verification of signatures in support of the Constitution Amendment Bill and Article 257(4) of the Constitution submitted by the Building Bridges Secretariat. 11. A declaration is hereby made that at the time of the launch of the Constitution of Kenya Amendment Bill 2020 and the collection of endorsement signatures, there was no legislation governing the collection, presentation, and verification of signatures, nor a legal framework to govern the conduct of referenda. 12. A declaration is hereby made that the absence of a legislation or legal framework to govern the collection, presentation, and verification of signatures and the conduct of referenda in the circumstances of this case renders the attempt to amend the Constitution of Kenya through the Constitutional Kenya Amendment Bill 2020 flawed. 13. A declaration is hereby made that county assemblies and parliament cannot, as part of their constitutional mandate, to consider a constitution amendment bill initiated through a popular initiative under Article 257 of the Constitution, change the contents of such a bill. 14. A declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it purports to predetermine the allocation of 70 constituencies, is unconstitutional. 15. A declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it purports to direct the IEBC on its functions of constituency delimitation, is unconstitutional. 16. A declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it purports to have determined by delimitation the number of constituencies and apportionment within the counties, is unconstitutional for want of public participation. 17. A declaration is hereby made that the administrative procedures for the verification of signatures in support of constitutional amendment referendum made by the IEBC are illegal, null and void because they were made without quorum, in the absence of legal authority, and in violation of Article 94 of the Constitution and Sections 5, 6, 11 and 11 of the Statutory Instruments Act. 18. A declaration is hereby made that Article 257, Sub-Article 10 of the Constitution requires all the specific proposed amendments to the Constitution be submitted as separate and distinct referendum questions to the people. 19. A permanent injunction be and is hereby issued restraining the IEBC from undertaking any processes required under Article 257(4) and 257(5) in respect of the Constitution of Kenya Amendment Bill 2020. 20. The prayer for an order that Mr. Uhuru Muigai Kenyatta makes good public funds used in the unconstitutional and constitutional change process promoted by the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report established by Mr. Uhuru Muigai Kenyatta is declined for reasons that we've given in our judgment. 21. The prayer for the orders that the Honorable Attorney General to ensure that other public officers who have directed or authorized the use of public funds in the unconstitutional constitutional change process promoted by the steering committee, by the BBI steering committee, make good the said funds is also declined for the reasons we have given in our judgment. 22. The rest of the reliefs in the consolidated petitions, which we have not specifically granted above, are deemed to have been declined. And lastly, this being a public interest matter, parties shall bear their own costs. But before concluding, we take this opportunity as a bench this is for on behalf of my 4 colleagues. We wish to express our sincere appreciation to the Council and parties who appeared in these consolidated petitions for their well-prepared pleadings and their well-researched arguments and submissions. If we have not referred to any part of the submissions made or decisions referred to us, it is not out of lack of appreciation for their industry.